Hi, I'm Juanita, and I'm here to help you develop an eagle eye for bad behavior called money laundering. Wet socks won't get you thrown in jail, but money laundering can, so give this training your full engagement so you don't get trapped in the wrong place at the wrong time. There's a lot to digest, so I encourage you to view the video more than once, make some notes, even discuss it with others so you maximize your learning and preparation in combating money laundering. Ready to get started? You may think you can spot a crook from a mile away, but not everyone trying to launder money looks like Al Capone. In fact, if you don't know the warning signs, you can be sucked into an illegal situation before you realize what's happening. So together, we'll go over some important warning signs which should help keep you safe. So what exactly is money laundering? Money laundering is the process criminals use while attempting to conceal the true origin and ownership of the proceeds of criminal activities. They take dirty money and use it in legitimate business to clean it up. There are 3 stages of money laundering. Placing, which gets cash from criminal activities into the banking system. Layering, which is where the original source of the funds is obscured or hidden. Integration, where it appears as if the income received is legitimate. Let me give you an example. There's a laundry owner by the name of Diego San Marie in Brixton. Mr. San Marie does more than launder clothes in his business. Very special customers can pick up narcotics for the right price. Mr. San Marie needs a way to hide the proceeds from his drug sale, so he hires Dawson solicitors to help him purchase a flat on the west side of town. Mr. San Marie puts a £50,000 deposit on the flat, and after a few days he tells the estate agent he's changed his mind. When Dawson solicitors deposits £50,000 into his account, that money has now come from a reputable source, and Dawson solicitors has become an accomplice for not checking the source of funds. Why should you care if your clients are crooked? All employees are liable under the money laundering regulations, regardless of your position and status in the firm. That's why this training is so important. Let's look at the main money laundering offences. They include concealing, which, just like the case of Mr. San Marie, allows a money launderer to pay funds into your account and then issue them with a client account check to deposit back into their account. Arrangement, which uses the money launderer's funds even though you suspect something isn't right. And acquisition, which is where someone buys or uses criminal property. So how can you protect yourself? Your main defense is your money laundering reporting officer, making an authorized disclosure to the National Crime Agency, protecting you and the firm against any charge. Once you report any suspicion, the responsibility passes to your money laundering reporting officer, your MLRO, leaving you to carry on with business as usual so your client doesn't get suspicious. I know reporting criminals to a higher authority can be a scary affair, but trust me, you'd rather put them behind bars than share a cell next to them. According to the money laundering regulations, each firm must have an appointed money laundering reporting officer and a system in place in order to make reports. They also require all employees to undergo anti-money laundering training. Since you're watching this video, you can check that one off your list. Now, think about it on a global level. Terrorism-related offences are less common than money laundering offences, but no less important. You need to be aware that the Terrorism Act 2000 exists, and that any activities you get involved with will be thoroughly investigated. Money laundering may seem like an old-school crime, but I assure you it's happening right now and with more technology available than ever before. It's believed that $200 to $500 billion is laundered throughout the world each year. In September of 2013, there were more than 300,000 suspicious activity reports made in the UK alone. Nearly 80% of those were reported in the banking sector and around 2% in the legal sector. It's a global problem being investigated and prosecuted in almost every nation in the world. Just as money laundering and mobsters were linked together in the 1920s, money laundering and terrorism seem to share close to the same relationship today. The global fight against money laundering includes agencies and governments working together to stop the crime, new laws and regulations, and freezing assets of suspected terrorist groups. The regulations also require the firm to have a customer due diligence process. What is CDD? Customer due diligence identifies and verifies the client's identity and address in a number of ways. For instance, by obtaining copies of photographic ID. It's also understanding the purpose and intended nature of the business relationship you've been enlisted to perform. It's important to ask all the right questions up front and before you begin work on any transaction. This is your first line of defense. So let's focus your eagle eyes on potential warning signs so you know what to watch for. First, look for ID documents that do not belong to your clients or appear to have been tampered with. Secondly, a client who tries to hurry you along without completing the client due diligence might have something to hide. Number 3, clients who avoid your questions should be pressed until you're satisfied with the information you've collected. And finally, clients who involve other countries where they seem to have no connection or can't answer questions to confirm why and how is certainly a warning sign. Make sense? In our industry, we must be alert to ways in which the services that we provide are at risk of exploitation by money launderers. Look out for suspicious people, suspicious assets, suspicious arrangements and transactions. Now that you know some warning signs, let's look at the 4 specific stages of client due diligence. Think of AVCO: assess, verify, know, and ongoing monitoring. First, assess the risk. When you're dealing with a new client, you'll want to complete an initial risk assessment. Refer to your anti-money laundering policy for additional information or speak to your MLRO. There is also a practice note on the Law Society website which specifically deals with AML if you require further information. Secondly, verify the identity. False names, passports, and other documentation are often used for criminal activities. Your AML policy will specifically confirm which documents you can accept. Electronic ID checks are also a form of CDD. When you obtain hard copy ID, ensure they are correctly certified, or if they are the originals, make sure you certify them correctly. Thirdly, know your client's business. Get to know them and how their business operates. This will help you spot behavior out of character. Ensure you understand the nature and purpose of the services your client wants you to provide. Ask them why they chose your firm, where the funds will be coming from, and understand the details behind this. It's important to obtain this information at the start of the case, and you will then be in a strong position to decide the level of risk involved and if it is something you are able to proceed with or not. When in doubt, speak to your MLRO. Finally, ongoing monitoring. CDD is a process that should be reviewed during each case. Has something changed? Is there more risk? If additional parties are added to the case, then CDD needs to be completed for them as well. You should assess at that stage if the change has grounds for suspicion. So when performing CDD, think AVKO. Linked to CDD is a process called reliance. It is where you rely on another regulated institution or person to conduct CDD for you. You remain liable for any failure in the client being appropriately identified. You can only rely on the following persons in the UK: a credit or financial institution, which is an authorised person, a consumer credit financial institution, a person in the following professions who is supervised by a supervisory authority listed in the regulations, such as an auditor, insolvency practitioner, external accountant, tax advisor, independent legal professional, but only if they are members of the professional bodies, government agencies listed. Here are some important reminders to always keep in mind. You would be committing a criminal offence if you assisted someone where there are reasonable grounds to suspect that the funds are the proceeds of crime. You would be committing a criminal offence if you failed to report suspicious behaviour or activities. You would be committing a criminal offence if you disclose to a client or third party that they are the subject of a suspicion report or that they are under investigation. This is known as tipping off. and could result in prosecution and the possibility of a prison sentence. Let's look at a few realistic scenarios you might encounter and how you can best manage them. What happens when you have a secretive or obstructive client? You might be able to tear down those walls just by asking the right questions. Be clear. You need further information, and their cooperation is appreciated. Don't be opposed to meeting clients face-to-face if possible. What about a client with a strange request? There are times when unusual requests or circumstances arise in any line of business, but here are a few examples of unusual cases that could warrant a second look into possible money laundering. A last-minute change of instruction, easily settled litigation, instructions from odd sources, instructions outside your area of expertise. It's quite possible that your client has international transactions. Remember, not all countries around the world have the same anti-money laundering standards, so it's important to remember that instructions that involve other countries with lesser regulation for money laundering will increase the risk profile for the transaction. The Financial Action Task Force and HM Treasury have published a list of countries which may present a higher risk of money laundering. Familiarise yourself with the list. Before we wrap up, let's review some of the circumstances that could signal red flags when presented to you. Your transactions may include business with property. Property-related warning signs which could lead to money laundering are ownership issues, method of funding, valuing, lender issues, tax issues. You must also be careful whilst doing private client work. There are risks which need to be considered, such as source of funds. Is the estate criminal property? Is the probate being administered abroad? Ask questions about a charity being set up. Remember, ask as many questions as you need to satisfy yourself. The possibility of being used to assist with money laundering and terrorist financing poses many risks, including criminal and disciplinary sanctions for firms and individual employees, civil action against the firm as a whole and individual partners, or damage to reputation leading to a loss of business. These risks must be identified, assessed and mitigated, just as you do for all the business risks your firm faces. And you should consider the type of client, business relationship, product or transaction, assessing individual risk for each client. And finally, the last annual AML report by a regulator identified increased risk in 4 areas. Increased private funding for property purchases as lenders require high levels of deposits, and home buyers seek funding from friends and family. Increased use of litigation and other alternative dispute resolution methods to attempt to launder funds. Hijacking of legal practice identities and creation of sham legal practices by organised criminals. And potential for organised criminals to seek to invest in legal practices through the licensing of alternate business structures. And that concludes this session on anti-money laundering. I'm Juanita, and until next time, remain eagle-eyed. Goodbye for now.